Okay, I guess I was on mute. Hello, everybody. Again, for a second try. Good morning and welcome in to more Brian Kohberger discussions. Hopefully, you can hear me now. If you can, let me know in the live chat. I actually unplugged my mic and plugged it back in to kind of move it around on this arm, but it's working now, so we should all be good. And it's less than 24 hours after our last Brian Kohberger update. More legal proceedings and filings and documents coming through, which again, I hope this seems like, at least for our channel, an earlier on jumping on board in this case to see exactly how the process goes and how much goes into it, and why these things are delayed and why the court system takes so long is because one side will ask for something. If the other side doesn't want to give it, they just wait the time period, and you can't file a motion to compel until after the time period. And usually after you send a 10-day letter, a good faith letter saying, please provide these documents, we think they're relevant. Then you object, then you file a motion, then you have to get hearing time. And in the gag order, we see how difficult hearing time can be, even when something is seen as an immediate need causing irreparable harm. So you can see how this stuff takes a long time. But these specific documents that were filed, when I saw them pop up, they seem like just normal responses to motions to compel and additional discovery requests. But there are some really interesting factors that can come and things we can learn from the discussions going back and forth between Brian Kohberger and the state. We can learn what there is, what they're going through, what each side thinks that they have. And I will say, all of the parties involved know that these documents will be public. And we're talking about both sides who want a gag order. Some may say the gag order is overly restrictive, but both of these sides want the gag order, and they both know which documents, like these, once they get filed, if they're not under seal, which they would have to ask for and the court would have to grant, they know the public is going to see these documents. And that, to me, I think is interesting. And I think we have to keep that in mind as we read defense documents that say, we need you to provide exculpatory evidence to us. And then the state calling something irrelevant. I think that that is all an indication of how the public is going to perceive these documents and this evidence that each side is discussing here. So I think that's going to be important for us to think about as we read these. If you guys haven't already, hit that like button. I may have said it when I was muted, but you'll never know unless you're a lip reader. And also subscribe. Hit that subscribe button, because when we see new documents come up in this case, especially when it's a little bit of a slower week, we're not covering any trials or anything that's really popping off right now besides this case. We are looking into a couple other cases. I can't remember the name of the case now, but it's in Utah. And I guess this woman has been charged with a crime against her husband. And she wrote a book for kids about grieving because they have kids. Seems like a wild story. If you guys are interested in that, let me know in the comments, please. And let me know by hitting the like button. And if you subscribe, you get to become a part of this community, and picking what content we discuss on the channel. So let's get into, first we'll go with the state's response to the motion to compel, which has some interesting aspects to it. All right, here we go. State's response to defendant's motion to compel discovery comes now. The state of Idaho, by and through the Latah County prosecuting attorney, and submits the following response to the motion to compel discovery filed by the defendant on May 4th, 2023. By way of background, here's what happened, and here's what we've provided. Okay, and we're going to jump right into it as we discuss these first parts that were provided. Approximately 10,000 pages of reports and other written materials, approximately 10,200 photographs, approximately 9,200 tips. Think about that. People trying to figure out what happened. People providing tips. 9,200. And then number 4, approximately 51 terabytes of audio, video, media, and digital materials. Now, some of you are probably more of an expert than I am on how big that is, but it's huge. If you think about like phones these days that can carry everything are 1 terabyte. So 51 terabytes. And I think that's like the upgraded data storage on a phone. So that's a lot of stuff that they provided in discovery. And this does a couple things. Okay. Providing this information as the state does a couple things. Number one, it looks like you're being very open and you're providing a lot in discovery, which is the point of discovery. Provide everything you have. That's number one. Number two, you look like you've already answered all of the questions and provided everything that they've asked for. We're going to get more into the motions to compel and specifically what the defense requested and whether or not the state did this. But if you think about this many documents and you see this as the public, all of you are saying, wow, that's a lot. 51 terabytes, that's crazy. 10,000 documents, that's crazy. But what does this also do? Well, you've seen it in movies and it happens in real life where important pieces of evidence can be buried within boxes or stacks of documents. And when you discuss 10,000 pages of reports, that's a lot of pages to go through. 10,200 photographs. It's a lot of photographs to go through. Now, anybody who's seen pictures like this in this kind of a case, if you, you take a picture of, this angle of the room, they take 25 pictures of that. So 25 pictures are the same exact picture. So that sometimes that happens. And it's easier to kind of sift through them. But then you talk about 9,200 tips. And when you're looking for other suspects or other people that could be connected to this case or somebody else that might have done it, sometimes there's 1, 2, 3, maybe 4 people you'd consider, but 9,200 makes it almost impossible for the defense to sift through and see which ones they think are important. They almost have to do their own analysis and their own investigation and then question law enforcement about it later, or then cross-check to see if the people they think did it or they think there's evidence that those people did it, if there is any evidence of tips or things like that from those other people. And Tina asks, isn't it their job? Yes, Tina, it is. However, some courts, and I've actually had cases, which this is the interesting way to look at this. I've actually had cases. It was a construction defect case. It was miserable. I did it because the person I represented was a family member, extended family member. And we had tons of work orders and receipts every time they went to Home Depot. And they asked for certain things specifically. And we provided them document dumps to make sure we got everything, because in good faith on our position, we wanted to make sure we provided all the documents and all the information that could potentially be relevant and we could potentially use at trial. We didn't know what was going to come up. We didn't know what was going to be an issue. If they would have said, well, you didn't pay for this chandelier. And we're like, oh, here's the Home Depot receipt that proves we did. So that's one way to think about it, is to be thorough. But the judge in that case here in Florida forced us to go through the thousands of pages of documents we produced in discovery and pull out some very specific invoices or change orders or pictures that correspond with some very specific discovery requests from the other side. So to me, I'm interested to see, I think this is going to go to hearing. And I think they're going to argue that, listen, Judge, 10,200 documents, that's not actually providing the answer to this specific question that we have. And we'll see if the judge makes the state go through and say, pick out the documents you're going to use to answer this question, or pick out the relevant documents. You've provided everything, great. So it's all discovered, and in the future, there's no discovery violations and things like that. But are they making it impossible for the defendants to actually find the relevant material? Now, everything could be relevant. Every picture could be relevant. Every document and report and tip could be relevant. And I think they're doing the right thing by providing everything. And I'm not at all saying the state is hiding anything. But sometimes if you know what you're going to use, we are not playing poker. We are not playing, Risk or Settlers of Catan, which I've actually never played, but these games where you hold things close to the vest and you surprise people at the end. This is not what we have in our criminal justice system. The state has to provide what they're going to use to the defense. The defendant has a right to know what the evidence is against him. And while aha moments come out sometimes in trials, listen, rebuttal cases like Johnny Depp, that's different. They didn't know that existed, or they didn't know it was going to be opened the door to. But in this case, the state is not allowed to hide the ball. The judge will not like that. And I'm not saying that's what they're doing, but that could come into play with the judge's ruling or in the hearing. So let's hear what else they said about the motion to compel. All right, defendant cites, let me make sure, did I make it big again? Yes. Defendant cites ICR 16F in support of its motion. However, the rule only refers to the procedure for responding to discovery requests. ICR 16B10 and K apply to requests for discovery orders. So there's a difference between discovery requests and discovery orders. With the above in mind, the state respectfully submits the following specific responses to items 1 through 6. So they say generally we provided thousands and terabytes of documents and photos and videos. That's generally speaking. Now we're going to talk specifics, which I think is important. The state has disclosed all items, and here's an important phrase, it is aware of. So what the state knows about, which you can't be held to know about things you don't know about, right? And something new could pop up later, as we saw in Murdoch and other cases, relating to the search and arrest of Brian Kohberger in Pennsylvania. The state is unaware of any body cam and dash footage beyond what has already been disclosed. So there already has been body cam and dash cam footage disclosed. They're not aware of anything additional to that. Now, what's interesting about this is the defense can talk to Brian Kohberger, and Brian Kohberger may say, I had these other interactions. They were wearing body cams. There was dash cams, whatever, that either haven't been produced to the state, or Brian Kohberger could be wrong, and there might not have been any camera footage from those, or I don't put anything past any of these real life cases anymore, but maybe it was destroyed or lost or whatever. But they could be getting information that the state doesn't have because they're talking to Brian Kohberger. Beyond what's been disclosed and on information and belief understands there is no body cam footage. Whatever we've provided is what there is, whether it's dash cam, whether it's, something at the station, but there is no body cam footage. Recordings of interviews and the defendant's transportation from the scene of the arrest have also been provided. So what's confirmed there? There are recordings of interviews and the defendant's transportation from the scene of the arrest in Pennsylvania. And all of that's been provided to the defense. Now, lab reports. We heard and read a lot about lab reports. Numerous lab reports regarding forensic evidence collection and analysis of items recovered from the defendant's parents' home, trash cans, and other receptacles, and the defendant's vehicle have been disclosed to the defendant. So, is this in the 10,000 plus pages of reports? Is the judge going to make them pull it out specifically and say, here are the lab reports? Or is it enough just to provide the document dump? What we also had to do is we had to OCR and number all the pages, and we'd have to say, page 1,123 to page 1,130, those are invoices connecting to the bathroom or whatever. So they may make them bait stamp the numbers, OCR so they're searchable, and provide them to the defense and say, for question number 6, see documents number 1,000 to 1,020, as opposed to having 10,000 documents you have to look through, which to me is fair. The reports include items from the FBI laboratory in Quantico, Virginia, as well as the Idaho State Police Lab. The defendant's attorneys and investigators have also been given direct access to view and inspect items seized from his parents' residence, including his vehicle. The state will continue to disclose additional reports it receives that are subject to discovery under ICR 16 and applicable case law. To the extent that the defense believes that certain reports may contain exculpatory information. Here we go. To the extent that the defense believes that certain reports may contain, and here's in quotes, that's why I put it in our title in quotes, exculpatory information, The state asks that the defense specify what exculpatory information they're referring to and the basis for their belief. And again, the state has a right to know if there's exculpatory evidence. They should know. Maybe they don't know. Maybe it'll make a difference in their charging decisions. Maybe they'll drop the case. Maybe they'll drop the charges. But again, it's not hide the ball. If there's something specific you think is exculpatory, just tell us. And if we have it, we'll provide it to you, because we don't want to have a Brady violation here. We don't want to violate the rules, so as to enable the state to make any appropriate additional inquiries. That's totally fair. Regarding the defendant's request labeled 2A, in addition to the above response, the state has inquired of the defense for clarification on ISB lab reports by number. So if you have a question about a specific report, let us know which one. Let's be specific here so we can help each other. Since there is a question about some duplicate numbering of the initial lab reports. ISP lab reports are separately numbered by forensic biology, DNA, prints, and forensic field services. The state has already been able to advise defense counsel that there is an ISP lab report number 25, which has been discovered, and there is another ISP report 11, which is pending review and approval at the lab. To assist the parties, the state has initiated specific inquiries about the status of all ISP lab reports and will make discovery to the defense as appropriate. So, what do we learn there? By the way, the word has been discovered or will make discovery means turned over to the defense in the discovery process. So we learn here that the reports have numbers. We need to be specific, but we also learn that there are reports like this ISP lab report 11, which have not been provided to the defense. It's pending review, and they'll only discover to the defense as appropriate. So there may be discussion at a hearing with a judge. What makes it appropriate? If they're doing lab testing, we should get a copy of it, just like the blood spatter in Murdoch. If it doesn't go their way and they're doing testing, we should get a copy of it. The state has provided recordings of MPD Detective Payne's interview with Mr. Kohberger to the defense. Ding, ding, ding. There's another confirmation that there is an interview with Mr. Kohberger with the Moscow Police Department, Detective Payne. Now, what's in that? I don't know. Will we ever see that? I don't know. Do you remember it being referenced at all in any other documents about what Kohberger actually said? I did not. And that's part of the gag order. But that's what makes interesting. So I will say, as much as I'll say nothing burger and whatever, we get another body cam footage. We didn't really learn a lot. It is interesting to see Kohberger's interaction with law enforcement. I think 3 times we've seen it now, pulled over for different traffic violations. So his interactions there tell me that in this case, his interaction with law enforcement is probably something similar. So we'll see. The state will provide any related reports and or notes as they are received and reviewed. So here's the question. Are there notes and reports that are related to this interview that they have not provided? And if there are, let's argue about whether or not the state should have to turn them over, or whether or not they should be protected or privileged or whatever it may be. But they're kind of admitting the existence of certain things the defense doesn't have. As with item 1 above, the state has provided the defense with reports, audio, video, and other recordings relating to the defendant's arrest and incarceration in Pennsylvania that have been received by the state. So they've turned over what they've received about his Pennsylvania arrest. We heard a lot about that. And did he make some statements? Did he ask if he was the only one? Number 5, the state has provided a copy of the report/memo referred to as request number 161 to the defendant. The state is unaware of any notes, recordings, or photographs. So they don't have some of the stuff the defense is asking for, which is a legitimate reason to not turn it over, obviously. But if it pops up later and magically gets found, the defense is going to be pissed, and they're going to point back to all these motions, the motion to compel, the state's answers. Were they lying? And that's why you have to be very careful and very detail-oriented here in discovery. But also why you provide 10,000 documents, because you could say, hey, look, it was in the 10,000 documents. The state respectfully submits that training records of specific officers are outside the scope of ICR 16 unless and to the extent that the officers will be offering expert testimony, which is discoverable under ICR B10. The state is willing to consider to reconsider its position upon a proffer by the defendant as to each officer. So let's talk about this point by point. First, the defense asked for training records and other, detailed records and background on all the officers involved. The state says no, only if we're going to call them as expert witnesses. My opinion is, the way I look at this stuff and the way I understand the rules, and they're pretty similar state to state, is it's somewhere in between. You don't get every single person that signed off on, was in the room, was standing outside the house. You don't get all the background information and all the training on everybody. But the state likes to call certain officers and call them experts based on training and experience, and call other officers, but they're not experts. They're just fact witnesses. I think any law enforcement officer or lab tech that was intimately involved, that's making reports, that could be called as a witness for the state or the defense, that has relevant information, that could testify, not just be an expert, they should provide that background information. The training, experience, reprimands, files, things like that. And again, you don't need to know about everybody that answered the phone or happened to be mentioned in a report, but the people that were intimately involved, I think the discovery should be provided on them, which the state goes into a little bit. And they say if the defense can make a showing and they show substantial need in the preparation of the defense's case for additional material or information not otherwise covered by this rule, and that the defendant is unable, without undue hardship, to obtain the substantial equivalent by other means, in the event of such a showing, the state asks the court enter such protective orders as may be necessary and appropriate to protect the confidentiality of the personnel records and any other sensitive information. So while this is fair, I think this is fair, I will say this is why stuff takes forever. The defense has to figure out what stuff is important, what officers may be important. They have to make a showing, and then they have to prove they can't get the personnel records. And then we have to have a hearing for the judge to say you can have this but not that, in order for them to get information. That's why this stuff takes forever. But it makes sense because you don't want to give everybody's information. As the state indicated in its responses to prior discovery requests from the defense, the state has and will continue to provide discovery in accordance with ICR 16 and applicable law. All right. So that's the response to the motion to compel. And basically what it says is, we've provided a ton of documents. We've provided the stuff specifically requested. We don't have some of the stuff, and when we get it, we will provide it. And the stuff with the officers, you need to explain to us why you need it for each specific officer for which you're asking. All right, I'm going to answer a couple questions, and then we will get to the response to the additional request for additional documents that the defense filed. Becky, is this what the defense was asking for that they hadn't provided? Yes. So the way it goes is you ask for things in discovery, the defense asks or the state asks, the other side responds or fails to respond or fails to produce the documents. And if they don't, you file a motion to compel, which happened in this case. You actually send a 10-day letter saying, hey, please provide the discovery. But then you file a motion to compel, which can force the court to order them to give the discovery. This is the state's response to that motion to compel. Barley Hops, Peter, law enforcement isn't compelled to turn over all their notes. Correct. But if the defense specifically asks for it, if the defense is going to depose an officer, certain notes do become discoverable. If they have already turned them over to the state and the state plans on using them in their case, or they could aid in the defense, then I would argue they are discoverable. There are some things that are absolutely discoverable, absolutely not discoverable, but most of this stuff we're talking about can be somewhere in the middle. Tina, I can't recall. Doesn't the defense also have to provide documentation to the prosecution? Thank you. Yes. The prosecution can file discovery requests to the defense, and the defense does have to produce stuff to the prosecution. Now, it's not as broad as what the prosecution has to provide to the defense. Hondo, this reminds me of SWAT. Is that where the character Hondo is from? Welcome to the crew, and Jalen as well. Peachy Smill. Peter, is this normal to do these requests like this? I'm so glad you asked, because when I can talk about it sometimes and we break down some specific interesting factors, it may seem like this is just like unprecedented and extraordinary and never happens in cases. But thank you for bringing us back to earth. Absolutely normal. I don't think a case goes by that we don't file a motion to compel, criminal or civil. I don't think a case goes by where one side doesn't answer discovery the way the other side answers it or has an objection to a discovery request. Leah McCrae, how long after death can you file a wrongful death? So, Leah, this depends state by state. Certain states, it happens on the date the injury occurred. If you live a lot longer after that, or when you find out what caused the death. Certain states, the statute runs from when the death happens. Certain states, the statutes run from anywhere from 1 year to 4 years, I think, is the most normal. Some states, you can extend it to 7 or even, extraordinary circumstances. But I think, national average is 2 years. But certain states have less, certain states have more. So it really depends. All right, let's get back to it. All right, the state's responses to additional discovery requests coming. Third supplemental request for discovery comes now. State of Idaho, buying through its attorneys, and they're answering or responding to this supplemental request. The state incorporates its other responses. The state has and will continue to provide discovery in accordance with ICR 16. Okay. So they keep saying that over and over again. When we get it, we will provide it. But they're also saying things like certain stuff is under review and we'll provide it as necessary or as we deem appropriate. And that's really not how it works. That's really not how it works. The state is not the gatekeeper, the judges. So if they have it and they don't want to give it, they need to object and tell the defense why they're not providing it so we can talk to a judge about it as a team. State, defense, judge, all in a room. We can get together and discuss whether or not it's going to come in. In regard to the specific request for standard lab discovery, the state has already provided the defense with everything it has received from the FBI lab. And that's the other part, right? As somebody pointed out, law enforcement, FBI, they could be delaying some of this. They might not be providing certain things. And if they don't provide it to the state can't provide it to the defense. The judge can order law enforcement to do things, of course. The state has also provided the defense with approximately 30 reports from the Idaho State Police Lab. Again, they love to throw the big numbers out. But just because you've provided 30 reports does not mean you've answered the question. Does not mean you provided the report they're asking for. That's like me asking for a specific question, for a specific picture of the car, of the, let's say, the airbag of the car. And they're like, we've provided 150 photos of the car. It's like, yeah, but none of them are of the front seat airbag, which is what this products liability case is about. So just saying you provided reports or pictures doesn't mean you've provided the one that they're asking for. Now, they very well may have. I'm just pointing out arguments that could still come in. The state has provided the Idaho State Police Lab with a copy of defense standard lab discovery. This lab discovery, I think this is important. They're saying, listen, you guys asked us, we provided it to the lab. And we're like, hey, can you give us this stuff? Have you already given us this stuff? Because that's fair too. Sometimes the state doesn't even know. They're like, what is this stuff? Hey, lab, did you guys give us all this stuff? And the lab will say, yep. And then they provided all to the defense. They've also comprised of paragraphs 1 through 10 and will supplement discovery as appropriate. As they give us stuff that is responsive to those questions, we'll give it to you, defense. The state specifically objects, and here we go. And every jurisdiction does this differently. We like for you to put what number you object to, what the objection is, so we can respond to that specifically. This is kind of a general objection, but they object to requests for personnel-related information as outside the scope of ICR 16, unless and to the extent that lab personnel will be offering expert testimony, which is discoverable. And again, this is where we get into the gray area. Expert testimony and anybody at the lab that's going to testify. Pretty much, as we've seen DNA experts or DNA analysts in every case, they're basically qualified as experts. So I would say if they're testifying at all, they probably fall under this rule. But this is fair. If they're not going to be involved in the case and they really haven't done anything except put something in a baggie, but sometimes that's important, as we saw in Murdoch. I don't think all their personnel information is discoverable. But again, I think it's at least arguable. We should take it to a judge and we should let the judge decide. And that's what the answer is going to be for a lot of this stuff. And that's how you have lawyers on both sides that see things differently. That's why I like open discussion and disagreement in the chat. If it's legitimate, right? And we're doing it to try to learn, I like stuff like that. And it's because two well-trained lawyers can disagree when they read the same exact verbiage and the same exact rule. They can both be practicing criminal, civil, family, whatever it is, for 20 years and see a rule differently. They can both have experience of hundreds or thousands of cases. And from my perspective, that's what the legal profession is. And we have a judge that makes a call. So when we disagree with stuff in the chat, it's cool. And we learn. And that's the point. We've always got to leave a little room open that we could be wrong, of course. And why we get to the spots that we get is important too. People are gifting memberships again. So thank you. I'm really excited. And another reason we did this early today is hopefully John is going to drive over tonight in hopes that we can film part of our members only live tomorrow. It's not going to post tomorrow, but I'm excited about it. Okay. In regards to the defense's request for genetic genealogy testing and search, the state objects and intends to separately file a motion in limine and motion for protective order under ICR 16L, I believe that is. Okay. So genetic genealogy testing and search, they really don't want to give this over. Now, doesn't mean they're hiding something. It doesn't mean it's exculpatory, because if it was exculpatory, they would not be able to not turn it over. A motion in limine would be denied. So we can just cross that off, that this genetic genealogy testing and search is some exculpatory smoking gun for Brian Kohberger. Cross it off, because if it was, the state would have to provide it. So I know that's where people are going to go immediately, because it looks like the state really wants to keep this out, really wants to hide this. But in reality, they know that they would have to turn it over. They know they would lose a motion in limine if this was in fact exculpatory. As will be more fully detailed in said motion. So we're going to get more on that later. So I'll save some of the analysis for when we get that. The state believes that the defendant's requested discovery is outside the scope of ICR 16 in that it does not tend to negate the guilt of the accused as to the offense charged, or tend to reduce punishment for the offense as contemplated by ICR 16A. It is not relevant. They're just basically listing all the reasons why you might be able to get this genetic genealogy testing and search and saying it doesn't fall into any of these categories. It's not relevant. It's not material to the preparation of the defense. It's not intended for use by the state as evidence at trial, and none of the documentation being sought belongs to the defendant as contemplated by ICR 16. Genetic genealogy research does not constitute reports of examination or tests, and any genetic genealogy research and attempt is exempt from disclosure under ICR 16 and applicable case law. So isn't this interesting? So first off, it's not relevant. Also, it wouldn't lead to something that's relevant. That's pretty broad. Also, and this is the biggest one, that how do you get around? It is not material to the preparation of the defense. How do you know what is going to be material to the defense at this point? Excuse me. They just snuck right out of me. How do you know what is going to be material to the defense? And for you to say it without the defense knowing what it is, to me, is also objectionable. Because for the defense to think that something might be relevant or might be material to their defense may be different than what the state thinks. So, what are they going to find here? Are they going to find the DNA also maybe connected to other people? Kohberger's dad is connected to other people. Kohberger's connected to other people. I think the defense wants this stuff because they want to see if there's any other potential suspects or something that they did wrong to connect Brian Kohberger based on the DNA, the genealogy, things like that. But I think what the state wants to prevent is if they searched other people or other suspects or other tips like if they ran 9,200 names through there, then maybe the defense is going to say, could have been this guy, could have been this girl, could have been this person, this one, that one. And it's just going to confuse the jury. It's not relevant. It's not fair. It's not something that should be used as evidence. So that's going to be interesting. And I'm interested if we get to see that motion in limine, or if they're going to seal it, if there's something protected or something they don't want to get out. But they mentioned and referenced it here, and even referenced the reasons they think it doesn't fall into a discoverable category. So hopefully we will see that, because that to me is really, really interesting. All right. Let's get to a few more questions here. Karen, has it been decided about cameras in court? No, it has not been decided. It doesn't look like it's going in a great direction, but hopefully we'll get cameras at least for the preliminary hearing. But like if I'm a betting man, or I'm trying to project for you all, the fact that everything that details anything about the victims, anything about the arrests, anything about the crimes themselves, it has started out by being sealed, and then they unseal some of it later, right? We can remember back to that. So if that's their MO throughout this case, it seems like they're probably not going to open it up for all of us to watch the preliminary hearing. I still have hopes that they do, but I don't know. The cynical Aussie, now I just have to work out what a membership means. So there's a bunch of different things you get with the membership. We got early drops to our early launch for our website and our merch. We give specific giveaways to members. We do member shout outs. We do members only lives and videos once a month. You get highlighted as green. So when you pop up through the chat, I can kind of see them more. And I think more of the questions get starred and things like that. So it's just for fun. Nothing huge. Don't anybody ever feel like you have to join or pay anything to be a part of this community or this channel. When you do, it's great. It's fun. I appreciate it. It highlights stuff. So do whatever you feel like doing, but we're happy to have you no matter what. Hi, Pistis campaign. There is another report concerning Texas lab. Interesting. I haven't seen that. Whimsical Druid. Question. Opposite to state providing numerous data to overwhelm defense, did the defense make copious requests for spurious data to impede the state's case? So here's what I'll say. The defense should make broad requests. In order to represent your client, you never want to have a situation where the state says, we had this piece of evidence, but you never turned it over to us, or you never asked for it, so we never turned it over to you. So the defense has to start broad, because the state knows everything and they have everything. The defense knows nothing, especially if your guy's like, I didn't do it. I don't know these people. I was never there. I've driven by the house before. So he may literally know nothing about anything. Now, doesn't seem to be the case here, but that's happened before where we're like, they've got the wrong guy. We've had a guy that's an engineer work for a huge company and had the same name as another guy in the company that did something not related to their employment. And it was so hard for us to try to piece together what happened. And when we did, they literally dropped all the charges. Basically ruined this guy's life because it was a heinous crime he was charged with. And I mean, so a woman of the night was in his truck. It wasn't our guy. And after the deed, he threw her out of the truck and ran her over. That's the crime. So imagine being a well-respected engineer with a job, getting charged with that crime, just to find out a year and a half later, whoops, it was the wrong guy. All charges dropped. Honest mistake by the state. But all she knew was his first name. She lived. And they were the same race. They didn't really look alike, but so that stuff happens, right? And then the defense doesn't know anything. So you got to start broad and then you can narrow it down. Scottish Jason. When does a motion have to fall within the gag order, i.e. not designed to lead to speculation that just clouds the waters? Usually one side or the other will file a motion to seal or a protective order or something to make sure it doesn't get out. They know if they file the motion on the public court docket, then it's going to be public. Harsh reality. What hair products do you use? So right now, so this is interesting. I've actually been talking to a couple people who have sent me some stuff to try. So we'll see if I end up liking any of it. But right now I just use a thing called Layrite, it's like a hair cream. It's not like a gel because I don't like for it to be like crunchy. I like for it to be like a little softer. I mean, it's wet in the morning after I take a shower and I just put a little bit in it. But see, this harsh reality, you are a member. This is something that we would normally cover in the members only stuff, which we try not to focus on legal stuff because the legal stuff is open for everybody. And that's the point of the channel is legal education and discussion. But we dive deep on some hair products, maybe in one of these members videos. Azam, off topic, Peter. One of my students is here. Please shout out Hannes. Hannes. I have a friend named Hanny. No S on the end. Karen. So saying the genealogy isn't relevant doesn't mean the DNA on the knife sheath does it. No. This could be a genealogy search, a website they went to. That's what I'm saying. I hope their motion gets more specific about what we're talking about. What exactly are we talking about? Mitzi Marie, thanks for the super sticker. Tina, I'm happy Harsh Reality asked the hair product question. I've been waiting to ask myself. It's amazing, and I'd like a slicked back look myself. Well, hey, some people like the slick back look. Some people are like, oh, you look like a slimy shark lawyer from New York. I'm like, it is what it is. But then sometimes they're like, you look like a surfer dude that's so chill. You can get all sorts of stuff with the long hair. You know, the guys with long hair get all sorts of stereotypes, and I'm here for all of them. Definitely, I usually don't get trial lawyer. I usually don't get that. All right, let's see. Layrite, I think that's what it's called, Layrite. Don't quote me on that yet. And I haven't used it for a long time, so I'm not necessarily like pushing anybody to it. But there are a couple that I do like that I'm talking to a couple of different companies that maybe I'll be able to get you like discounts or something like that on. Because we've had people reach out before. No products I've really loved, but there are some that I kind of do like that we'll be talking about soon. And some of them do have to do with men grooming and stuff. So we'll see. Thank you, Mindy. All right. Let's see if we've got anything else here before we take off. All right. So yeah, so you guys got a little idea. And, you know, I don't want to bore anybody with stuff that doesn't care about that stuff and is just here for the law stuff. So I try to hit that right off the bat, dive deep, and then at the end sometimes or in the members only videos, or I make it clear in the video title, we're going to dive into some other stuff, more personal stuff. Today is my daughter's 10th birthday, which I just can't believe I have a 10-year-old. So that's also why we're doing it in the morning, because I will be busy in the afternoon and tonight. So I appreciate you guys coming on, hanging out. As always, hit the like button on the way out and make sure you subscribe. We're still trying to get to 250. It's a slow crawl at this point, but I know we'll get there. Appreciate you all. Until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.